Why don't we go ahead and get started today on our session on asset protection and long-term care planning. Thank you for joining me today. My name is Mike Fiffik. I'm the managing partner here at Fiffik Law Group. We have a great team of elder attorneys and estate planning practitioners and estate administrators, one of which is my partner, Kevin Frankel, who heads up my Philadelphia office in Radnor, Pennsylvania, the Philadelphia suburbs. We're very happy to share this information with you about long-term care planning and asset protection. It's a big part of our practice. We do quite a bit of this work with folks. Estate planning, very key for everybody to have. Two-thirds of Americans don't have an estate plan in place, which is really critical to protect their family. We do a lot of trust work as well. So we draft all different types of trust for folks, and we advise people on all manner of elder law related type of issues. So we really would invite you to check out the resources that we have on our website. We have quite a bit there, and or to schedule a one-on-one with one of our practitioners, in this regard. One of whom I think is attending the session today, Jen Beaumonte. So, Jen, just to let you know, I've enabled you to speak in case
Oh,
you want
thank
to
you.
chime in on something. So feel free to do
Thank you.
that. Great.
Hi, everyone.
All right. So aging facts and figures in the United States, right? We got lots of folks, 54 million adults age 65 and older. So we've got the age wave that's coming in. It's almost 20% of the United States population. We're getting older, as evidenced by what I have on the rooftop there as well. So this is something that is going to be an issue for lots of folks in the coming time. And not just for them, right? Maybe you are a child and you've got a parent who's in their 70s, 80s, even 90s, and you're the one that's helping them make decisions about long-term care planning. So this really applies to the caregivers, the kids, the nieces and nephews, anybody that's helping somebody who has an interest in these issues. Lots of interest in these topics amongst this population. And I would say that one of the big reasons why folks are interested in this is because of costs, right? Folks are concerned about the average costs of long-term care all over the country. And we're talking in particular about Pennsylvania because that's where we practice. Private nursing home bed in Pennsylvania, on average, about $380 a day, 11,000 a month, $132,000 a year if you're going to be in skilled nursing. A semi-private room is slightly less, but it's still very expensive. If you're not in skilled nursing and you're in personal care or assisted living, right? Those are a step down in care. Care is still very expensive to pay for. Sometimes the average cost per month exceeds somebody's regular income, especially from Social Security. It can be very draining for somebody to pay for. And even getting care at home, if you want to stay at home, and most people would love to stay at home if they're physically able to do it, if their home is set up in such a way that it's safe for them to be home. Getting a caregiver to come to the house, not really less expensive in many instances. So the cost of this care is something that we really have to face. Some folks call it the gap, right? Because this is a gap in insurance that covers this kind of a things. So here are some of the common concerns that we hear from folks whenever when they call us to talk about these issues. How are they going to be able to afford the high cost of long-term care if that's something that comes into our life? And it is becoming more likely that it will because we're living longer, we're living healthier, right? So that really does mean that more of us are going to probably need to be thinking about long-term care in some way or another. Will we be forced to drain our life savings? That's what a lot of people are concerned about. You work all your life to save money, right? To care for yourself, but also to pass on to the next generation to make their lives better. Are you going to have to blow the whole wad, so to speak, in order just to pay for long-term care? Very, very, very big issue. Will you have enough money to support your spouse? Maybe only one of you needs to go into long-term care or skilled nursing, usually because of a sudden health event like a fall, broken hip, a stroke of some kind, where your situation is going to be such that you can't return home, but your spouse doesn't want to move into a skilled nursing facility with you. How are you going to pay the expenses of your home and the skilled nursing facility? That's a real difficult situation for folks to grapple with. Will you have anything left of your life savings to pass on to your family to make their lives better than yours? A big concern. And will there be any liens on our home or on our estate if we go into a nursing home and can't afford to pay for it? Or are there going to be a lien? Somebody going to put a lien on my house? That's something that we hear from folks, as well. So let's dig in and talk a little bit about these issues. And I always think that the best place to start is to just survey the types of long-term care that are out there for folks, right? So we've got home care, right? So you're living in your home and somebody's coming in to help you. You can have private duty, which is somebody that cooks for you, cleans for you, does your laundry, helps you with your shopping, those types of things. And then you have a professional duty home care where they're providing more like medical services. Usually that comes into play after you've had a surgery or a health type of event where they got to come in and provide some wound care or physical therapy or something like that. But those are the types of home care that are out there. There are some services that are providing a little bit of a bridge between home care and going into the facility. Services that like Life Pittsburgh or Life Steps, those are two providers in the Pittsburgh area that will take you from home to their facility during the day for various types of activities and then back home, at night. That can be a nice sort of bridge or half a loaf type of a care situation. That's something that is becoming more common, or it's another option for people. We have independent living, meaning you move into usually a continuing care retirement community of some kind. And this is apartment living, except it's apartment living for seniors. And they may provide you with certain types of services like meals, dining hall, dining rooms, those types of things, perhaps even laundry and some other types of services. But by and large, this is like living in an apartment, except with some help kind of a thing. You've got assisted living and personal care, which in Pennsylvania are in essence the same. Those are marketing terms, but they pretty much provide the same type of care. And the level of care provided there, meaning how sick you can be and still remain there, depends widely between providers. Some provide very little in the way of assistance as you get less well or have more challenges, right? But others will give you some options to stay there as long as you can before you might have to transition into skilled nursing, which is the next one here, and that's the most expensive, right? That's the most expensive type of care that you can have. Some continuing care retirement communities offer one or more of these services all on the same campus. So you could enter in independent living, and as the need arises, transition while on the same campus into assisted living or personal care, and then transition into skilled care, all without leaving the same facility or buildings on the same grounds, so to speak. So that's what a continuing care retirement community is. And then you have hospice, which denotes treatment at the end of life. That can be provided at home, or that can be provided in a facility. Maybe you're in skilled nursing, but you can have hospice care come in and provide services to you. But there are also some providers that have a specific hospice house of some kind where you might go just specifically in that season of your life. But those are the different types of long-term care, by and large, that are out there. So let's talk a little bit about how you pay for long-term care other than, okay, other than skilled nursing. So how do you pay for these things? So by and large, most of them are private pay. Personal care, assisted living, those by and large, there's going to be private pay by and large. There might be some veterans benefits. If you're a wartime veteran, you may have veterans benefits that can pay for some portion of the care in the event that you qualify for that. You may also have long-term care insurance of some kind. And that's a great thing to consider buying. It really can defray your costs. Certainly less expensive to buy when you're younger, but you can buy it when you're older. I wouldn't say you could buy it when you're 80, but you can buy it when you're older. It just will probably be a little bit more expensive, but it is a great way to preserve your assets, to care for a spouse, to pass savings on to your loved ones. It's an excellent tool for doing that kind of a thing. So now let's switch into who pays for skilled nursing care, because this is very different. And there are primarily two different payors, right? Medicare and Medicaid. Those are two completely different programs. So let's talk about them both, because there's a lot of misunderstanding about which of those, what each of those is. And certainly I'll be happy to answer any questions that you have along the way here. So feel free to drop them in the chat or the Q&A, and I will definitely answer all of those at some point in the session here. So for Medicare, right, it doesn't really kick in to pay for skilled nursing until you've had a hospital stay of at least 3 days. And not all hospital stays are the same. A new term or new phrase has come up called a qualified or qualifying stay. So if you're there admitted for observation only, that doesn't count as a day for purposes of kicking in Medicare eligibility. You have to be admitted to a Medicare certified nursing facility within 30 days of your qualifying hospital stay. So it isn't any facility. It has to be a Medicare certified nursing facility. And you'd have to need some type of skilled care, skilled nursing services, physical therapy, or other types of therapy. That's what Medicare is going to pay for. And Medicare is only going to pay for a certain period of time, and it's only going to pay for costs for up to 100 days. And it doesn't pay for the full cost for the full 100 days. So the first 20 days, it's going to pay 100% of the costs. And then after that, it starts to ratchet down until you get to day 100. So it pays some, but not all of the expenses for staying in skilled nursing. So that can maybe be good for a short-term stay following a knee surgery or hip surgery of some kind. But if you're going to need a longer-term stay in a skilled nursing facility, you're going to probably run out of coverage under Medicare and have to start paying otherwise. So if Medicare doesn't cover it, or if you've run out of coverage, or you begin that 21st day in a skilled nursing facility, we're going to have to figure out who else is going to start covering the $11,000 a month tab. And here are some other payors. Long-term care insurance, right? That can pay for some of it. Long-term care policies used to be better. Now they're being restrictive because it's so expensive to stay in skilled nursing. So this is something that we're seeing a little bit less of. Veterans benefits can cover skilled nursing. Private pay, right? You might have to just pay out of your own pocket from your income or your savings for skilled nursing. But medical assistance, Medicaid or medical assistance is also available in certain situations to pay for skilled nursing. Now, here's something that a lot of folks don't realize. Not all nursing homes accept Medicaid payments, right? You could be in a skilled nursing facility, but Medicaid may not be eligible or available to pay for your care there. So the nursing home is going to need to be licensed and certified by your state as a facility that can accept Medicaid payments for services provided to residents there. So it's very important to understand whether that facility that you're looking at or is being recommended to you, whether medical assistance is going to be available to pay at some point there. I really wouldn't suggest that you go anywhere other than a place that has a medical assistance license, but you'd be surprised. And it's really doesn't depend on the quality of the facility. There are high quality facilities that will accept medical assistance, and there are high quality facilities that will not accept medical assistance. So it isn't associated with the quality of the facility. You really have to ask the question. Some of them choose not to have medical assistance licenses at all. Just because the facility has beds available does not mean that a new resident who's eligible for Medicaid is going to get covered. Some facilities make a limited number of beds available for Medicaid eligible residents. And that's because the reimbursement that they get for medical assistance is typically far less than their cost of providing care. So they don't want to have everybody there being paid by medical assistance. Otherwise, they're going to lose their shirt. That's just not a way for them to run their businesses. So that's just a practical issue. And most facilities that have a medical assistance license are not going to accept a new patient who is Medicaid eligible beginning day one. So your providers of choice, meaning you don't want to be in any skilled nursing facility if you can avoid it. And that's no knock on them. They provide wonderful care, but people don't want to go there if they can avoid it. They would rather stay home. But sometimes that's just not a choice that you have. And so there are providers out there, and there are places that if you have to be somewhere, you'd prefer to be these places rather than those places. And the ones that you would prefer to be probably aren't going to accept you Medicaid eligible from day one. It's going to be the lower tier providers that will be willing to do that. So you're probably going to have to be willing to private pay for some period of time in order to get into a better facility. I'll say that. No offense intended for anybody out there that's in the long-term care or the elderly care field out there. So Medicaid isn't necessarily available to anyone, right? There are going to be financial eligibility requirements, and they relate to your income and they relate to the assets that you own. So let's talk about those individually. Let's talk about the income test. And these are my terms. There's what I would call a gross income method of eligibility, meaning if your gross monthly income is less than a little bit over $2,800 in 2024. These are PA numbers. These numbers may change from state to state because Medicaid, although it is federally funded, it is state administered. So the income levels for eligibility are going to vary from state to state. This $2,800 number is the 2024 eligibility threshold for Pennsylvania residents. There is also a net income method, or what we in Pennsylvania call the medically needy program, that you can take your net income or income and reduce it by medical bills, including nursing facility bills that you incur each month to spend your income down to the medically needy only level of qualifying for medical assistance. It's a lower number. That you could still qualify. So those are two ways from an income standpoint that you could qualify. But you also then, let's say that you're eligible from an income standpoint, you also have to be eligible from an asset standpoint. So it's both. It's not either or, it's both. So income and asset eligibility, or resource test is what we call it. So the income method that you qualify under is going to dictate what resource allowance you're going to be given. So the gross income method, if that's how you qualify, you can have up to $8,000 of resources in some circumstances. If you qualify on the net income method or the medically needy method, you can only have $2,400 of resources. Very low numbers, right? But it's not as straightforward as that. So let's talk a little bit more about resources. There are assets that count for getting to that resource allowance amount, and there are assets that you can own that don't count for purposes of eligibility. So countable assets include all of your solely or jointly held assets, meaning spouses that own assets together, right, or even separately, are going to be considered assets for purposes of applying for medical assistance. So that means bank accounts, investment accounts, the applicant's retirement accounts. If they're married, their spouse's retirement accounts don't count. Cash value of annuities, cash value of life insurance are very common assets that are resources that count for getting to that very, very low $2,400 or $8,000 threshold. Real estate that is not your home, so your home doesn't count. It's not considered at all. So real estate that is not your primary residence. So if you have a vacation home or a camp up on the Allegheny River somewhere, that the value of that property is likely to be considered an asset that for eligibility purposes. A second vehicle, the value of a second vehicle. If you have assets in a revocable living trust of some kind, those are treated as your assets for purposes of eligibility. And any assets pretty much that you have control over, other than your retirement accounts, are going to be considered whenever you're applying for medical assistance. Now, assets that don't count, right? We can really separate them into two different categories. That's exactly how the form looks whenever you're applying. Assets that don't count would be your primary residence up to a certain amount of equity, which is $713,000. It's a lot of money. For most people, it's just not an issue. One vehicle is not considered. Your household goods, all your tchotchkes, your furniture, your clothes, things of that nature, pretty much don't count. Life insurance with a face value or a cash value of cash value, that is, of less than $1,500, that doesn't count. Term life insurance, which has no cash value, doesn't count. Burial plots and markers usually don't count. If you have a prepaid burial plan of some kind, as long as it's below a certain value, it won't count. And that changes from year to year. And it also varies from county to county in Pennsylvania. So it's 19,000 and some change for Allegheny County. That's where I am, but it might be different in your county. Your spouse's retirement accounts are not considered. Your own retirement accounts typically aren't considered. And then there's a certain amount that you can set aside for your spouse who is going to continue to live at home that can be sheltered or protected, that isn't going to disqualify you for eligibility. So let's talk about married couples. And I've got a couple of abbreviations in here. The institutionalized spouse, the one that's living in this facility, it might be referred to as IS, and the community spouse, meaning that the one that's still living at home, right? Still living in the community, not in the facility of some kind. So spousal resources, this resource assessment is taken and completed. It's a snapshot at that time of countable assets whenever the person who is moving in moves into the facility, and we can protect these assets. I think I talked about this before. And they come up with a determination of what the countable assets are, what the value is. So if you're over the threshold in countable assets of 2,400 or 8,000, right? Then that's going to dictate how long, how many months, or how much you're going to have to spend down in order to get to that 2,400 or $8,000 resource threshold so that you would be eligible for medical assistance. So you might have to spend that on the facility, meaning pay out of pocket until you get down to that number. That's certainly what the facility would tell you you should do, right? They want you to spend it on them. They're entitled to get paid. They're providing a service. They're entitled to get paid. But you can spend that on other things. And we're going to talk a little bit about that type of a strategy in order to get you eligible for medical assistance sooner rather than later without losing the benefit of that money, right? Without losing the benefit of that money for you or for your spouse or for your loved ones. But the long and short of it is, if your countable assets are above the allowed threshold, then that money is going to render you ineligible until it goes away in a way that's allowed in order for you to be eligible for medical assistance. So let's see, I'm going to skip these examples. Okay, so let's talk about some medical assistance and asset protection myths. Get a lot of this because it's complicated. People don't understand how medical assistance works, and they really don't understand how to protect their assets in the event they need to be in a nursing home and they want to apply for medical assistance. They don't want to spend all of their money paying for a nursing home and leave nothing for their families. That's a big concern that a lot of people have. But there are a lot of myths out there about these types of things. And I want to just talk a little bit about the common things that we hear. So myth number one, that you have to spend everything that you own in order to get Medicaid, or long-term care medical assistance is what they call that. That's just not true. Medical assistance isn't just for poor people. You don't have to spend everything that you own in order to get medical assistance. There are things that we can do to protect those assets, right? So that you and your family still have the benefit of them, and also enable you to be eligible for medical assistance in order to pay for skilled nursing. So that you don't have to spend everything on the nursing home in order to become eligible. That's a myth. You really don't have to do that. Myth number two, I can transfer my home to my kids and protect it from nursing home costs. I'm going to say, yeah, you probably can, but the problem is that when you transfer an asset to somebody else, it's a gift in essence, right? Whenever you apply for medical assistance, they're not just looking at the assets that you own on that day. They're going to look at the assets that you own on that day and in the 5 years before you applied. Because what they don't want you to do is to give away all your money and then apply for medical assistance, right? They don't want you to be able to do that. So and cause the government to pick up the tab for your care. So that's why there's this 5-year look back. Maybe you've heard that phrase, 5-year look back. But they do look at all of the transfers of assets that you did in the 5 years before you applied for medical assistance. So some people think about transferring the house to their kids whenever they're concerned that they're going to need to go to a nursing home really soon. Well, it's not going to protect it, right? That's going to disqualify them for medical assistance for a long period of time. The value of the home divided by the average cost on a monthly basis, basically. There's going to be a period of ineligibility or disqualification for benefits, and you're going to be stuck with that. There's no way to undo that kind of a thing. It's very difficult to do it. So there are lots of other problems transferring your home to your kids before you pass away. It could cause them to pay a lot more in capital gains tax if they sell your house than they would if they just inherited it from you, because inheritance tax is about a third of what the capital gains tax rate is if they were to sell your home. So you're going to give them a big tax bill by just giving them your house in most instances. So there are better ways of protecting your home. We can talk about that. So myth number three, I can put my kid's name on my bank account and I can protect half the money from nursing home costs. You can't. Same reasons, right? There's that 5-year look back. You can't put their names on your bank account and half of it is disregarded for purposes of eligibility. This doesn't work either. I don't know where that myth comes from, but I do hear that from time to time. How about this one? I can transfer all of my assets to my spouse and I'll qualify for Medicaid. Again, not true. Whenever you apply and you're married, other than your retirement accounts and the other assets that don't count, all of the assets of a married couple, including jointly titled assets, are considered your assets if you're the applicant for medical assistance. So you can't just transfer it all to your spouse and, Shazam, you're eligible for medical assistance. So myth number 5, I have to give up control of all of my assets in order to protect them from nursing home costs. Also, not true. We have a lot of planning techniques that are 100% legal. We don't do anything that's illegal or unethical or anything else. There are lots of tried and true uh, nursing home planning techniques, asset protection techniques that we can employ that will allow you to have the benefit of your assets, right? And you don't have to give up complete control and enjoyment of them. Myth number 6, it's too late to do asset protection planning once you're in a nursing home. Again, also not true. If you go into a nursing home as a result of a sudden situation, and you find yourself ineligible for benefits because you have too many assets, we can still do some things in order to get that person eligible sooner rather than later, and also reserve the benefit of those assets for them or their spouse that's still living at home or their family. So don't think that it's too late. If you or a loved one is in a nursing facility, you should still be calling and talking to an elder law practitioner to see what options that you have available to you. So let's talk about some basic asset protection techniques that are commonly used. And I'm going to talk about this in two different ways. Proactive versus crisis planning, right? People proactive or well, let's talk about that in a minute, right? This means that you're positioning assets in such a way that you're going to protect them before you need long-term care. So this is somebody that comes to us. There isn't, a sudden health situation. Presently, they're not in a facility now. They're just doing some prudent planning in advance in anticipation that they might need to have nursing care, right? This is really the cheapest form of long-term care insurance, right? It's not insurance, but you're ensuring that you're not going to have to spend all of your assets on care in the event you're going to need this in the future. So that's what proactive planning is. Crisis planning is, you've got a sudden health event. Husband's in the hospital. They're going to transition him to skilled nursing in a couple of weeks. What can we do now, right? Or the person's in the facility, their skilled nursing facility. What are our options? That's crisis planning, right? And there are two different approaches to lots of different techniques depending on your situation. And we've talked about that 5-year look back. So who are the crisis clients, right? I'm going to say aged 75 and up. Some folks might say maybe a little bit younger than that, 70 or 65. It really depends on your health situation, right? There are very healthy folks that are 70 years old that they're not really worried about needing skilled nursing for some period of time. But, a sudden health crisis can happen at any time as we get older. So definitely people can have different opinions on, crisis planning and what age you should really be thinking about that. But if somebody has a sudden health crisis, which an extended care in a nursing facility, somebody who has assets or income that prevents them from being eligible for Medicaid immediately, right? We want to take a look at what your situation is so that we can assess, are you going to be eligible right away, or do you have more assets and we need to do some protecting of those assets? Even if the person has no heirs or a spouse to leave assets to, we can still help them preserve their estate for whatever it is that they want. Perhaps they want to preserve it for charity or something like that. There are lots of different things that we can do. Lots of folks want to protect their assets and use them however they want and be generous with them as opposed to having them all spent on long-term care. So who are the proactive clients? Who are the planners, right? I'd say age 60, 65 and up, including children of parents who are that age. So mom and dad can be doing this planning on their own, but maybe mom and dad aren't quite so proactive and you're a child and you're advising them, or you're a caregiver of a parent. You really should be somebody, you should be thinking about encouraging your parents to get that done or leading the way for them in order to get that done. So caregivers can get the conversation started as well. And they should have a positive net worth of some kind, right? We want to take a look at that, especially if you have a home. That's something that we definitely would want to protect. So if you own a home, you should be thinking about doing some proactive planning. Clients with a special need child, or a spouse that has disabilities of some kind also should be doing some type of planning. It's really is heartbreaking to save your money and leave your money to a child with special needs that is dependent upon government benefits. And by leaving them money without doing some planning, you cause them to be ineligible for those benefits for some period of time. Your money just gets spent down before they can then go through the whole application process of being eligible again, which in and of itself can be a nightmare. So, you're really wasting your saved money. You can leave that money for the benefit of that special needs child in a way that will benefit them and also cause no disruption whatsoever to their eligibility for benefits, whatever it is. It just requires some advanced planning. So any parent with a child of special needs of any age should really be thinking about doing some asset protection planning for that child. Very important. So here are some strategies that we typically use, right? First and foremost, don't skip the essentials, right? You got to have your basic estate planning documents in place. Everybody should do this. A will, a revocable living trust, or revocable trust. It could be, those are synonymous terms. A durable general power of attorney in Pennsylvania, we call them hot powers. And that might be maybe different terms in different states, wherever it is that you are. But really, you want a power of attorney that gives your agent the ability to work with your assets in a way that would allow them to do some medical assistance planning, right? To change beneficiaries, to make gifts, to create trusts on your behalf. You'll want to give your agent the ability to engage in that type of planning for you. And sometimes the power of attorney has to specify those powers, or your agent doesn't have them, right? So you got to make sure that the power of attorney gives you the ability to do that. A healthcare power of attorney and a living will. In Pennsylvania, those usually are combined in one type of a document. Also very important, essential. And then you'll want to make sure that the beneficiary forms that control your accounts are designed to work in concert with your will or your revocable living trust, whatever of those documents you're using as your primary estate planning document. You want to make sure that they work in concert with one another, especially as it relates to IRAs, any type of qualified plans. You can put some special controls on that money for beneficiaries. You may want to have the money left to your beneficiaries left in trust for them to protect them from divorce, from addiction problems, from creditor claims. Lots of important things to do here just in these essential documents. So I highly encourage you, don't skip over getting these things in place first and foremost. But if you're in a crisis situation, right? Short term, not looking out in advance, but we're doing some short term things. Here are some strategies that we can do. If you find yourself in the facility and you've got too much in the way of assets and you're ineligible, one option would be just to pay the private pay for your services until you've spent down to that amount. But you can also make other purchases, right? That that are of assets that don't count, right? And get yourself to eligibility faster and also get some benefit out of that money. So you're in a personal care facility, you're in a skilled nursing facility, you've got, $30,000 in assets over the limit. You might buy in your revocable burial account. If you've not prepaid for your funeral, you can shelter $19,000 in one of those types of accounts and get some benefit out of that rather than just pay it to the facility. Again, I'm not knocking the facilities, but medical assistants can pay them once you're eligible. You can prepay for burial plots and grave markers. You can make repairs and improvements to your residence because it doesn't It's not a countable asset. So if you need a new roof, if you need new windows, if you need to modify the property so that your spouse can stay there long term, right? You can make those improvements to the property. Spend the money on your house rather than spending it down for care. You could purchase a new home if you don't have one, or a new car. A new car is a great way to sink a lot of money into something. Maybe pay off a mortgage or a home equity line of credit, pay off your debts. You know, these are prepay real estate taxes or homeowners insurance. There are a lot of different things that you can spend money on that you're going to get some benefit out of that will get you down to an eligibility situation for long-term care medical assistance. Sometimes this strategy is called a smart spend down, right? Let's decide what we're going to spend the money on and do that. So get some benefit out of it. The next strategy I'll call exempt transfers. So you can transfer some money um, to people and not be ineligible. You can't just give it all away. You're going to be disqualified. That's not an exempt transfer. That's a disqualifying transfer. But you can transfer some assets to a spouse to make sure that they get the maximum amount of that community spouse resource allowance, about $150,000. You can give that to your spouse. They can shelter that. It's not going to prevent you from being eligible for benefits. You can transfer a house to the spouse or a child under age 21 or a child with special needs. You can actually transfer your house out. You can transfer a home to an adult caregiver. There are a variety of transfers that you can engage in that will not disqualify you from benefits. That'll get you down to an eligibility situation. You can pay your lawyers, right? Pay your elder law attorney. That's an approved expenditure. So pay for the advice, because remember, the sooner you get to eligibility for medical assistance, the sooner you're not having to pay $11,000 plus a month for skilled nursing. It's a huge savings for you to get to the eligibility period sooner rather than later. Get some advice. It's worth the money, right? You can spend a ton of money on long-term care insurance, or you could pay a practitioner and to get you down to an eligibility level sooner rather than later. You'll save a ton of money by doing that. So I highly encourage you to do that. Now, let's switch over to some proactive strategies. These are advanced strategies that folks that are thinking a little bit longer term, we can do. First thing, it seems too commonsensical, but a lot of people don't really think about it, is you might want to look at what pots of money that you're going to pay your bills. What money do you want to spend first, right? You may look at the assets that a couple has, right? And maybe a couple that I was counseling with last month, right? Married couple in their 80s. He has the majority of the money because he was the breadwinner during their marriage. And the vast majority of his money is tied up in an IRA or a 401k, retirement accounts, right? His spouse, on the other hand, has some assets, but not as much, right? If she has to go to a facility, the only assets between those two that are going to count is her money, because his money is in a retirement account, right? It's not going to count. So if we're thinking about what money they want to spend first, right? And there is a pecking order in some situations. We might say, why don't we spend her money first? Because she'll be closer to being eligible if we spend down her money now rather than spending money out of his retirement accounts. So you might make some choices about what money you're going to spend first in order to put you in a better situation, or put one of you in a better situation in the event the need arises for skilled nursing. So that's a proactive strategy. We might also suggest that we prepare an asset protection trust of some kind for your house or for some assets. and transfer them into that trust to shelter them from long-term from the eligibility for medical assistance. Now, there's going to be that 5-year look back on those transfers, but if we're doing it sooner rather than later, we can put together a plan such that even if you have to go into nursing care within 5 years of transferring assets to this trust, that we can get you through that 5 years so that that house is protected, right? And once it's protected, now it goes to your family and it's never going to be touched, even if you get long-term care medical assistance. So that's another big strategy, especially for homeowners, that we suggest. There are other types of irrevocable trusts that you might want to use, especially for life insurance or charitable trusts. There are other types of irrevocable trusts that you might transfer money into in order to shelter that money. Because after the 5 years, money in these asset protection or irrevocable trusts are not countable assets for purposes of applying for medical assistance. It may be necessary to change beneficiaries on your IRA or your 401k, your retirement plans, in order to render those ineligible as assets. There are some special rules that relate to that. There are some other strategies of giving money away, so making a gift to your family and converting this money that's an asset into an income stream, and that asset is no longer a resource that prevents you from being eligible. So there's some types of things that we can do. If you have a caregiver of some kind, especially a family caregiver, they can be paid. This is a way for you to funnel money out of your name to a family caregiver, and for it not to be considered a gift. So if you have a child that is caring for you, without a legitimate written personal care agreement, um, if you apply for benefits and somebody sees that you're paying that person $3,000 a month, if there's no care agreement, those $3,000 transfers every month are going to be considered gifts and they're going to render you ineligible. But if there is a legitimate personal care agreement and they have to be structured in a certain way, then those are going to be those transfers, even though they're within that 5-year look back, aren't going to prevent you from being ineligible for care. And you might even be able to purchase a life estate in a child's home to live there for whatever period of time and transfer money to your child in that way. So there are lots of different strategies that we can take a look at if it's right for you to protect those assets. Another one is to, again, convert a resource or assets into an income stream, and the income will hopefully will not make you ineligible for care, or maybe it'll pay for the services for a period of time. So the strategy is to convert a countable resource into a stream of income for the applicant or for their spouse. So it can support your spouse during a period of ineligibility if it puts you above a certain income level. So examples of these would be immediate annuities, where you have cash in an investment account, we take it, purchase an annuity, and now we've converted an asset worth, let's say, $100,000 into just a stream of income. And the stream of income might still put you below the eligibility income level for eligibility. Or if you're applying for medically needy, your costs may still lower you. Maybe we make a gift to a child and they give you back a promissory note to pay you back. That can also convert cash into a stream of income that would then allow you to be eligible for medical assistance. So that's just the type of a strategy that we can employ. But these have to meet certain criteria in order to be legitimate for purposes of medical assistance. These types of transfers are irrevocable, meaning once you do them, you can't undo them. It's a lump sum purchase typically. They have to begin paying immediately. So it's an immediate annuity. It's an immediate promissory note. There are no deferrals or balloon payments. So it has to pay on an equal monthly basis. So those are some strategies of converting a resource into an income stream and thereby rendering you eligible for medical assistance. Now, something also important for you to understand, if you do qualify and if medical assistance pays for your long-term care, after you pass away, your estate will be subject to what's called estate recovery, meaning the state wants to get paid back. They'll have a lien on the assets of your estate. They're going to want to get paid back. So what does that really mean? The rules are going to be different depending on where you are in the country. They're going to vary from state to state. But in Pennsylvania, the estate recovery applies to your probate estate, meaning assets that pass in accordance with your will, right? So if you pass away with a home in your name and you receive medical assistance, they're going to have a lien on your house. That's really the biggest source of estate recovery for the state. They're going to put a lien on your house in order to get paid back the amount that they paid to the facility on your behalf. Bank accounts in your name are going to be subject to estate recovery. Could be from retirement accounts that have no beneficiary on them other than your estate. They're going to be able to claw money out of those as well in order to get paid back. So there is a state recovery that's out there. That's one of the bigger reasons behind doing some asset protection trusts for your home if you're a homeowner. Because if you don't do anything and you pass away with that house in your name, even though it doesn't count for purposes of eligibility up front, right? If you die with that house in your name on the back end, the state's going to have a lien on it to get paid back. So they either get you on the front end or they get you on the back end unless you've done some planning. So in order to avoid estate recovery, here are a few tips, right? If you have accounts, make them joint or payable to someone on death because it only applies to a probate estate. So if you've got a bank account that is a pay on death account, it's not going to go through probate and it will avoid estate recovery. Life insurance, make sure that you name somebody as the beneficiary and never your estate. I would never suggest that you put my estate as a beneficiary on a life insurance policy. Never do that for a lot of different reasons. Your residence is the most recovered asset, as I had mentioned. You know, if you're married, retitle the house into the sole name of your spouse that's still living at home and not in the facility. That'll avoid estate recovery. Or if you're unmarried, sell it, give it away, do whatever you want to do with it, but don't pass away with that house in your name. Otherwise, it'll pass through your probate estate and be subject to estate recovery. If you have a will, your spouse should revise their will and disinherit the spouse that's in the facility. That's the last thing that you would want, is to pass away. You've got a spouse that's in skilled nursing and you've left them all of your estate. They're just going to be ineligible for medical assistance. So if you are a spouse and you've got a loved one or a spouse in a skilled nursing facility, if you haven't changed your will to take them out of it, I know it seems cruel, but it's just the good money thing to do. You really should get your will changed to disinherit your spouse or to have that money paid into a trust of some kind so that it can benefit them, make their life better, and there are ways of doing that without rendering them ineligible and causing that money to be spent down. So that's my presentation. I'll just suggest that we've got lots of estate planning resources available on our website to take a look at, including lots of stuff on estate planning, trusts, elder law related matters. My partner, Kevin, does a weekly webinar, Wills and Trusts, and he talks a lot about these issues in greater detail. So you can register for that on our website if you go to the events page. That's done weekly at noontime, Eastern Standard Time, and I'd be very happy to have you participate in that.